Justice Breyer, thank you very much for making time for this.
Thank you.
I have to start with the question that's on everybody's mind, obviously. Why is this book that you've just written so small? It's a very small book, and I'm used to bigger books, so why is this book so small? I mean, why didn't you get a bigger book?
This is the Constitution, and it's smaller.
Okay, all right. Well, now, on the Constitution is something that the Founding Fathers came together and they wrote, and at the time that they did it, the first branch of government was the legislative, second was executive, and third was judicial. Do you think they really felt the judiciary would have the power and the Supreme Court would ever have the power that it now really has, the power and the authority, or that was something that happened later?
Now, I think what they did think, and it wasn't just John Marshall, it was Hamilton and it was a lot of the founders. They thought that the court would have the power to say when the other two branches had exceeded the limits in this document. This is a document that creates frontiers. It doesn't really tell people what to do.
Right.
I mean, it's like, did you ever listen to Sergeant Preston of the Yukon?
Right.
When you were growing up? It was cold up there on the Canadian frontier. Is abortion inside the frontier or outside the frontier? So there are frontier questions. And what they didn't want is the executive or the president to go beyond the frontier. But who should say? The president? Well, he might just say everything he did was fine. Well, what about Congress? Congress, Hamilton thought, they're experts on popularity. Absolutely, if they're not going to be there very long. So, this document is written for the least popular person in the United States, just as much as for the most. So maybe not Congress. Well, what about the judges? He thought, perfect. This does have something to do with law. And they said they do not have the power of the purse. They can't pay people, and they don't have the power of the sword. Many years previously, Cicero had said, if you don't have the power of the purse, you don't have the power of the sword. The only way to get people to do what you want, if you're a leader, is to try to do the right thing. Try to create justice in the courts. Not so easy to do, but that's where the power of the court lies.
In the famous case Marbury v. Madison, where the Supreme Court for the first time said, we're declaring a law unconstitutional, do you think the Founding Fathers thought that was what the Supreme Court would do, or they?
Yes. Okay. I do think that, but I mean, it was controversial, but I think for the very reason, if you read the Federalist Papers, I can't remember which number. So let's say 76, and then I'll just hope none of you remember which number. But
I notice a lot of justices of the Supreme Court carry around the Constitution all the time. Is that because you're going to forget what's in it, or you just like to remind people, or you just read it over and over again?
You never know when somebody's going to ask you a question. You see, somebody says, what does Article 3, Section 19 say?
Okay.
And they expect you to know.
Okay, so you have
So you have it here. Yeah, there it is.
There it is. So your book, this book is a interesting book in the sense that it came from a series of lectures you gave, named after somebody who was an ideological, let's say, opponent of some of your views, and that was Justice Scalia. So were you a friend of his, even though you had ideological differences?
Yes, I think so. We would debate those differences, and we'd go. I thought we had a terrific debate in Lubbock, Texas. There were several thousand students who'd come. They'd never seen a Supreme Court justice, and we talk about our differences. You know, I say, hey, if I had your theory, my goodness, do you think George Washington knew about the internet for free speech? Do you think he knew? And Scalia would say, I knew that. Well, good point. Then he would say, I'm not saying my theory's perfect. He would say, you know the two hunters, they're hunting bears, and one's putting on his tennis shoes. Where are you going? And he says, bear's coming. He says, you can't outrun a bear. He says, yeah, but I can outrun you. Right. See, that was his view of my way of deciding cases. And of course, I never, and I still, 28 years now, I've never heard a voice raised in anger in that conference room. I've never heard one justice say anything mean or even snide.
Nobody the table or anything like that?
What good would that do? I try to explain that to the students. You know, you get all excited, and all that happens is people disagree with you, think, well, you know, he's all excited, he must be wrong. And that's so true. So we get on well personally, and we're friends personally, and we disagree on some things. Not as many as you think, but some.
It's not always been the case. There was a Supreme Court justice who refused to talk to or be in the presence of Justice Brandeis because he was Jewish.
McReynolds.
Right. So it hasn't always been that friendly, but you're saying right now, since you've been on the court 28 years, people don't yell and scream at each other.
And they don't insult each other, and they're not rude to each other, and it's a professional job, and you go in and do your best professionally. And if you want people to listen to you, the best you can do is to think through this problem. Listen to where the other person is coming from, and see what you can contribute to that thought.
But sometimes the dissents are a little bit tough on the person who wrote the majority opinion. Nobody takes that personally.
I get that question a lot, and I used to get it more when Nino Scalia was on the court. And the two of us would be there, and somebody would ask that question, and I'd try to answer it because I didn't want him to. And I'd say, look, I know you're not aiming that question at me. You're aiming it at Nino. Okay, I get it. But what you don't understand is that some people suffer from a disease. It's called good writer's disease. Okay. And if a good writer finds a felicitous phrase, he won't give it up. Let him destroy himself, let the world come to an end. It's like a good comedian. You can't give up that joke. Now, that's Nino. He is a very good writer. He has a felicitous phrase, and we all know that, and we don't take it personally.
Now, COVID has changed the court in some ways. It used to be the case that if you wanted to hear an argument in the Supreme Court, you had to line up and get into line, and maybe you get room, or maybe if you knew a justice, you could get a special seat. But generally, most people in the public couldn't hear the oral arguments as they were being given. Now, because of COVID, the oral arguments are broadcast live as they're being given. Will that continue when you go back to live arguments where the justices are hearing from the lawyers in person? Will you go back? Will you continue that practice, or nobody knows yet?
I think, from what I know now, I think it will continue.
Oh, really?
I don't know how long, but I think because COVID is still around, we'll be in the courtroom for the oral arguments, but I don't think the courtroom will be as full, and I think that we'll broadcast it over the radio.
But you wouldn't expect television ever, or at least not in the foreseeable future.
I don't know, expect it ever. Look, a whole generation, I don't say I said this, but there are 1 or 2 generations that are growing up that don't know anything but television. Right. And they will, except for screens, and they will, in fact, not understand why there's no television there, and then there will be.
Let's go back to your earlier life. I worked on Capitol Hill, and you worked briefly on Capitol Hill. You were a Harvard Law professor. I'm just curious, when you go to Harvard Law School and you're at the top of your class, when you start Harvard Law School, there's always kind of an intimidation factor. You have 600 people, you have to figure out, are you going to be good or not? When did you realize you were really good at law school kind of things, taking exams? Did you know right away you were going to be a great law school student and therefore become a potential law school professor, or were you nervous the first year or so?
I think I was pretty nervous. I mean, I remember talking to a friend of mine I'd been an undergraduate with, and he was there too, Paul Docket, actually. And we both said, well, this is the end of our great careers. That was after our first year. And we both did pretty well in law school.
So you were in the Harvard Law Review, and when you're in the Harvard Law Review, sometimes you get the clerk on the Supreme Court for another justice, and you clerked for?
Arthur Goldberg.
And what was that like?
It was terrific. He was only there for 3 years, but he loved his clerks. There were only 2 clerks for each justice then. And we'd go out to lunch every Saturday. And you remember people did at one time work on Saturdays. and
There used to be mail on Saturdays.
What?
They used to have mail delivery on Saturdays.
Yeah. We used to go to Duke Zebert's for lunch, and he would, it was fun. He was great. He was an enthusiast. He had loads of energy. Jack Kennedy said that he was the smartest man he ever met. And wonderful job. We all,
So you clerked for him, and then you went to teach at Harvard Law School.
That's right.
And when you went to Harvard Law School, did you say, this is going to be my life? I'm going to be a professor, nothing terrible about that. You can teach great law school students and so forth. Or did you say, maybe someday I'll be on the Supreme Court, maybe I'll be a judge? Was that in the back of your mind?
I didn't think maybe someday. Anybody who thinks maybe someday I'll be on the Supreme Court, I mean, I don't want to say there's something wrong with him, but there is something wrong.
So, after teaching at Harvard Law School, you got a very good reputation. Senator Kennedy invited you to come down and work on his staff, I think to work on regulatory reform.
Yes.
And that's where I first encountered you, and I was working on Capitol Hill and so forth. You've got a very good reputation. And then something happened that was a surprise to people. President Carter nominated you to be a judge on the First Circuit, and that's not a surprise given your reputation and so forth, but it required a Republican to sign off on it, Strom Thurmond, one of the most conservative Republicans. And at the last day of, I think, Carter's administration, is that right?
I don't know.
Pretty much the last day, I think it might have been the lame duck session.
Yes, it was the lame duck.
The lame duck session where Strom Thurmond could have said, I got other things to do. He consented to letting you go forward, and of course you were confirmed right away unanimously. Why did you think Strom Thurmond said he would let a presumably somewhat liberal Harvard Law professor get on the First Circuit?
I mean, those were days, it was a different day. You remember that. People did try to work together. Right. And every single morning, Ken Feinberg, who was like, I was chief counsel and he was a general counsel or something of the Judiciary Committee, and we would have breakfast with Emory Sneeden, who was a former JAG general, and was Strom Thurmond's chief person on Judiciary, and we would plan the day. We planned out the day. We wanted no secrets. We wanted to try to accomplish something. And we'd figure out how do we color it red for this party and how do we color it blue for the other party. But the important thing is, if it's desirable, let's try to get it through. That happened a lot. I can't say there was no conniving, but Ken and I and Emory used to call what we did open conniving, openly arrived at.
Okay. So you went on the First Circuit and you had a very good reputation there. And then you were being considered to be on the Supreme Court. And so you came down for an interview with President Clinton, but you had a bike accident, and you had a lot of injured bones, if I recall. So did you think that was bad karma, that you had this accident before you had the interview, and did that affect your ability to do the interview well, or it didn't make a difference?
I have no idea. I mean, that's the truth of the matter. And later I thought about it. And of course, the newspaper people wanted to say, weren't you terribly disappointed, da, 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 da. And I said, I'll tell you why. I said, well, you know, it's not such a terrible thing in your life to be seriously considered to be on the Supreme Court, even if you're not appointed. And that's about the best you can do. And I was thinking partly I said that because it's true. Okay. And partly I said it because I did have children. Hey, my friend, you don't always win everything you want. And my goodness, what you want those children to learn. And you want them to learn, fine. Sometimes you'll get everything your heart desires, not very often. And sometimes you won't. And you better be a good sport about when you don't, as well as when you do.
Well, Mick Jagger has a song about that. You can't always get what you want, and so
right.
You didn't get it.
That's after my generation.
Okay. So Justice Ginsburg was appointed first, but then you were appointed next by President Clinton.
Yes.
So when you got on the court, how had it changed from when you were a clerk? Was it much different, and were you surprised by the changes?
Yes. I thought it was different in this respect when I clerked. I felt It was a court with a mission. What mission? In 1954, the court had decided that Plessy v. Ferguson, rightly, was down the drain. And legal segregation is contrary to this document, equal protection of the law. They said it in 1954, and we both know what happened in 1955. Nothing.
Right.
Next to nothing. 1956, yeah, double nothing. 1957, a rather brave judge in Little Rock said those Little Rock nine, those 9 brave black students are going into that white school, Central High School. But the governor, Governor Faubus, said, maybe those students have a court order, but I have the state militia, and they're not. And Eisenhower and Faubus, thanks to Hayes Brooks, who was the congressman, got together, and Hayes Brooks and, well, Faubus told the president, Mr. President, I'll let them in the school, and he went out and told the press the opposite. Well, Eisenhower was pretty angry. So he called in Jimmy Burns, who had been on the Supreme Court, ran our economic war effort in World War II, and was a moderate on race, governor of South Carolina. And Jimmy Burns said to him, Mr. President, if you call in troops to send to Little Rock, you better be prepared to reoccupy the South. You better be prepared for a second Reconstruction. The best that'll happen is they'll close all the schools. But Herbert Brownell, his wise counselor, attorney general, said, no, you've got to do it. And Eisenhower, I'd like to see that at the monument that they're building for him. He called in 1,000 troops from Fort Bragg, the 101st Airborne, and everybody knew who they were at that time. They'd been hung up on the steeples in Normandy. They were the heroes of the Battle of the Bulge, and they went to Little Rock, and they took those 9 black children and walked into that white school. No, I'd like to say that's the end of the story, but it wasn't. What happened was after a few months, the troops had to withdraw. And when that happened, the school board said, we're not going to integrate anymore. And when that happened, a very famous case went to the Supreme Court, Cooper versus Aaron. And when that happened, all 9 justices signed the opinion saying, integrate now. Do it. Right now in Little Rock, hey, but there are 9 people. Maybe there could have been 900, maybe 9,000. Faubus closed the school. That's what happened, for those of us who remember and those of us who don't. But they couldn't keep it closed, because that was the era of Martin Luther King, the Freedom Riders, and suddenly the North woke up, and others woke up and said this is an intolerable situation, and eventually, through a lot of work and a lot of moral effort and a lot of physical effort and a lot of organizing effort and so forth, eventually, legal segregation was brought to a conclusion. And the reason that I find that story important, and I told that story to a woman from Ghana who is the Chief Justice, who is trying to improve the constitutional system there, and asked me, why do people do what you say? And my response was, ma'am, 301 million people in this country, and 300 million are not lawyers. That comes as a surprise. And those are the people you have to convince. Convince what? Convince that they should try to follow the courts or the rule of law when they don't like it, when they think it's wrong, when they think it's absolutely wrong. And I mean, Bush v. Gore, I heard Harry Reid say the remarkable thing is that people followed it even though they thought it was wrong. I thought it was wrong. I dissented. Thought it was very wrong. But I told a group of Stanford students this, and I said, I know what you're thinking. You're thinking that it's too bad there weren't a few riots. Too bad there weren't some guns shot. Too bad, too bad. Oh, really? Before you think that, before you think that, you go and turn on your television set or whatever and see what happens in countries where they don't have a rule of law. And that's why I wrote this book. In a sentence, that is why. I want people to see in some detail. It's not moralizing, it's my experience. And I want them to see what the court can do. But when you say the court can do, it doesn't mean 9 people. It means the country as it's come to develop a long time, 200 years, and then maybe we have a country that can use this weapon called the rule of law in order to prevent some pretty terrible things. So that's what I want those students to understand.
The Brown v. Board education decision was unanimous, and it appears that Chief Justice Warren wanted it to be unanimous and worked hard to get that to be unanimous. The Bush v. Gore decision was 5-4. Do you have a lot of unanimous decisions these days, or they don't get that much attention? And do you really have a lot of 5-4 decisions, and they get all the attention, it seems? But is that where the court really has its arguments with each other, the 5-4 decisions? And
no, not necessarily. I think it depends. I mean, it was, when I looked a while ago, it was like almost half were unanimous. Now I think if you put in the unanimous and 8-1, 7-2, it's a little more than 50%. And the 5-4s were about 15, 20%, something like that. Not always the same 5, not always the same 4. And I noticed often in the newspapers, when they have a 5-4, something like that, the newspapers will say, in an unusual combination. So I counted up the 5-4s, and there were more where it wasn't the usual combination. So I said, how can it be an unusual combination when that's the majority? I don't know, you can figure that one out. But I mean, look, even now when you read so much about it, I mean, we did just decide a case about gay rights, and say the holding in the case was employers cannot discriminate against gay people, and that was the judges who signed that. One of them would be viewed as on the conservative side, very, very much interested in the literal text, and others, probably more like me, are interested more in purposes and consequences. But what you read about are the ones that the press thinks the public will be interested in, which usually has a political or a social content. And they'll say, that's the most important. I don't know. One of the most important decisions I wrote this last year was called Google versus Oracle.
right.
And it took a year for me to write that. It was about copyright and something called programs, interface programs. And I was told that was very, very important. Well, for me, it was like learning Latvian. I mean, I don't know how I did that. But you see, it's I'm not saying I see what they're saying. I see what they're saying. And it's true that a lot of the sort of exciting cases are more close.
So when the way the court works is you have, how many cases a year? Maybe 70 to 80?
Yeah,
a little bit less than it used to be. Right. Why do you take less cases? It used to be 120 or so cases a year, I think, and now you're less.
It's a good question, and I've been reading about the Taft Court.
Right.
That was 1921 to 1930. And they had many more cases, but the reason they had many more cases was there was a law that said the Supreme Court had to take appeals in a large number of cases. Then that law was changed in 1925. Then the number of cases began to go down like this. Then, when the Warren Court was there, remember there were a lot of changes. There were lots of changes in the law. To dismantle segregation required lots of cases. And then the court began to interpret the Bill of Rights so that it would apply to state officials. And then Congress began to enact a lot of laws. Well, when Nixon was president, they passed all kinds of regulatory laws, like the EPA. Justinian said, when you have a lawyer and you pass a statute with a lot of words, every word is a new legal case. So I think part of that extremely high number reflected that. But one thing I learned yesterday, reading this, which I found rather interesting, the number of cases has gone down, say 120 to 90 or whatever it is. The length of the opinion has doubled.
So you're working harder. You're working harder.
No, well, that's what I used to, I think that may be beyond law. I mean, I think people get used to working at their job, and they'll work at their job. I mean, that's what Holmes said. He said, first you try to master a subject, and then it masters you. So these are fairly hardworking individuals.
When there's 70 or 80 cases, you have, the briefs are filed. Do all the justices really read all the briefs, or they read the main briefs? You can't read all the amici briefs.
Yes, you can.
You can, okay.
What I do.
All right, so you read all the briefs.
Well, let's put it this way. If there are 80 briefs in a case, which is rare, okay, here's what I do. I first will read, well, maybe the petitioner's brief, maybe the Solicitor General's brief. I want to see what the government is. The respondent's brief, that's red. The first one's blue, the second one's gray, the third one's red. That's because they think,
read
all right.
Those.
Then a yellow one, which is the response, is pretty good. And then the light green ones, which are amici curiae for the one side and dark green for the other side. Well, by the time I've gotten to the amicus briefs, I know the case pretty well, at least I think I do, so I can go through it pretty quickly. But what I'm looking for is something in that brief that I haven't seen in some other brief.
So the justices don't discuss the cases after they read the briefs. They have oral argument, is that right?
Usually.
And the oral argument, the justices ask questions. Are the questions really designed to get answers from the lawyers, or to maybe persuade your colleagues of something through the way you ask the questions?
Both.
Okay, so
the best kind of question in my mind is a question, I don't know the answer. I think you may, Mr. Lawyer, know something that will be helpful genuinely to me in this case, and no one else has asked the question yet. One of the good things about our doing this in COVID is that Clarence Thomas, who rarely asks questions, the last year has been asking questions all the time.
Have you asked him why all of a sudden he's asking questions after all
because some people have been somewhat limited, and he doesn't have to feel somebody else asked the question or is about to do it. That would be my guess.
All right, so
but that's more or less.
So the arguments, are the arguments so good in some cases that they persuade you differently than how you thought you would be, or mostly the arguments are good, but they're not really going to change your vote?
Well, I would say that if you mean change your vote from like A to not A, 5%,
okay,
10%, if you mean change the way you look at the case so that you think it will be it'll end up being written differently, I think quite a lot, 20%, 30%, and that matters because it's those words on paper and the way it's written that have a tremendous influence on the law.
There are experienced Supreme Court litigators now, and they presumably know how to make cases. But do you ever get lawyers who never argued before in the Supreme Court, and they don't do such a great job? Do you feel sorry for them, or you try to help them along and say, well, look, let me give you an easy question, or you don't do that?
When I was on the circuit, one of the most successful lawyers was one that no one could understand because all the judges would come in to try to help him. And if the judge comes in to try to help you, then he's really hooked, you see, at that point.
After the oral arguments, you go back.
But they're very well. The bar and the
They're pretty prepared these days.
They're very prepared.
So you go back and you have your conference. And in the conference, the Chief Justice asks people their points of view, what they're going to do, and I guess the chief says his view first, and then you go down in order of seniority. And does anybody ever change their mind after they initially say this is what they think?
Yes.
Oh, they do?
Yes. Nino thought not. I think yes.
Okay.
And I think that the conference has become somewhat more important. And I think the secret to the conference is to have thought this through. It's not just announcing what you are going to do. It's what is the main point here? And listen to, that's what I learned from Senator Kennedy, listen to what the other person says. Listen. And if you listen, well, maybe you can make a contribution. Not, I have a better argument than you. That gets you nowhere. I mean, obviously, the other person thinks, I have a better argument than you. That's zero. What isn't zero is paying attention. And Kennedy did this. You know, he'd say, if someone you think you disagree with, if they'll talk enough, you'll find something there you do agree with, and you try to...
But do the justices, let's suppose you have a decision, it's 5-4, and one justice kind of go to another justice's chambers and say, you know, your argument isn't so good, and maybe you should do something different, or is everything just done by memos and writing? You don't have people going down the hall and saying, let's have lunch together, and maybe I can persuade you my position is better than yours. Does that ever happen?
Most of it is memo, but quite a lot can be visits to chambers. But if I'm going into your chambers, I'm not going to say, no, your argument isn't so good. This would not be a helpful way to start the conversation. And if you go into somebody else's chambers, you better be prepared to listen to them, as well as hoping that they will listen to you. And then you try to see, and that's what I learned in the Senate, that's what you try to see is, where is there some common ground? And is there common ground enough that you can work with it? And if you work with it, and Kennedy said this a lot, if you work with it and you get somewhere and it's successful, don't worry about the credit. If it's a success, there'll be plenty of credit to go around. And if it's a failure, who wants the credit? And credit is a weapon. And I saw Kennedy do that so much, as probably you did too with Birch Bayh and others. Push the other person out. I mean, that in front there. And the object is the joint achievement. And
now,
it's easier said than done, but it's sometimes done.
Do the justices write the opinions, or do they have the clerks write them, or is it a combination? How does that really work?
Depends on how much the justice wants to take of what the clerk will do. I think virtually all of us, I mean, I don't know if everybody, but I mean, what I'll do is I've had one or two clerks working on this case from day one when we did the cert petition. So I'll say to her, please, you produce now, if it's assigned to me, I want a pretty lengthy thing. Put down what you think, but cover these points. All right, then I will get this. You can call it a draft or you can call it a memo. And I read it. And then I will take it and I will take the briefs I want and I will perhaps go home or perhaps just into my office and I have the word processor there and I'll write my draft. Now, why? Because I was a law school professor. Law school professors just can't resist. And so having done that, I give it back to her. And she thinks hers was better, but nonetheless, then she'll redo that, and then I'll redo that, and eventually we'll get something we're satisfied with.
Now, you pick the clerks you have 4 clerks now. Each justice has 4 clerks, I think.
4, not 2.
So do you interview them in advance, or they're
Yes.
they're all top of their class at great law schools? Do you ever have a clerk and you say, oops, I made a mistake? That doesn't happen?
Well, it hasn't so far.
Okay, well, probably after 28 years, it's probably not going to happen again. I mean,
Oh, we'll hope so.
So, okay, so when, let's talk about what's called the shadow docket. For lawyers, people who are not lawyers, what is the shadow docket and why is it becoming such a big thing?
The shadow docket is some word that somebody who's not on the court made up.
Okay.
Okay? What it is that in between hearing the cases on which we have decided to hear, someone will make an emergency motion. Now that's what it is, an emergency motion. The country is divided. I'm in charge of the First Circuit, for example, but everybody's in charge of some circuit. So if there is a litigant in the First Circuit who believes that he needs immediate attention to issue an injunction or to stop an injunction, well, then he'll file it with me, and I'll look at it, and most of them there isn't much to, and so it's easy to deny it. But some, there is something to. And then I usually will refer it to the whole conference. And if I should have and didn't, he can go to any other judge and it will be referred to the whole conference. Most of these that are the subject of the whole conference are death cases, and at the very last minute. Because of COVID, I think, there have been some recent cases which did not just involve the death penalty or something that wasn't too difficult. And there, I thought I was in the dissent in those cases.
Well, the most recent abortion case.
I was in dissent. I thought it was wrong, and I thought we should have heard the whole thing. It was a procedural matter. They didn't decide the substance of the statute.
But there will be a case, presumably working its way up to the court, but it might take a year or so for a...
well, there is a case in November where that's the subject matter.
So your book is, which I did read and I thought was very enjoyable, and I learned a lot, and I wish I had read that when I went to law school. I would have been a better law school student. But what I wanted to ask you is, you talk about the peril of politics. That's one of the main points. You don't want the court to be seen as political. Yet the court can't control that because you have members of Congress who are political, and you have lots of things that are very political. So for example, when you have confirmations these days, it's very, very political, it seems. And when you were confirmed, it wasn't that political. But today you have these votes that are very, very narrow, and the Democrats are always voting for the Democratic nominee, president, and the Republicans are voting for the Republican president's nominee. How do you think that you can avoid politics when you've had the rest of the country looking at the court in such a political way?
Well, you have about 4 questions in there.
Well, pick any
And
one.
they're very interesting. They're very interesting. I mean, what I usually say about the confirmation process is I was the confirmed person. I wasn't the confirming person. I was the appointed person, not the appointing person. And so asking me about this is about like asking for the recipe for chicken a la king from the point of view of the chicken. Okay.
All right.
So I've used that a lot. But we did work, both of us, in the Senate, and I wonder if you agree with me about this. I feel pretty strongly that the senators will ask the questions and vote in ways that they believe their constituents, by and large, want. And if they don't, they won't be senators for too long. So, if you think we're too much at loggerheads, it's too much a question of your political affiliation and not enough of a question of, well, where can you get together in the merits? That's what I tell the students at Stanford. It's pretty tough. I say, you get out there and participate. You get out there and try and convince people. You get out there and talk to people who disagree with you and find out what they think and see if you can find some common ground. That's easy to say and not easy to do. The thing that Sandra O'Connor used to think, which I certainly think, is the first thing is teach civics in the high schools. Everyone in this country. Of course, it's their government. They ought to know how it works, and they better. And second, participate. Second, vote. Second, you do that. Take part in public life. Be on the library board. Be on the school board. My goodness. And finally, practice. Practice a lot. I thought that was a plus up in Cambridge. One little plus I could find is that people really did find groups up there and went around to old people who were in houses to see they had enough to eat and to see that everything was okay. And it wasn't just Cambridge, Mass. It was here in New York. It was in St. Louis. It was in San Diego. It's all over the country. And that's I got some reassurance from that because I thought we as a country one of the things we were known for was working together on projects, even with people with whom we disagree. So if you say it's hopeless, I say no, it's not hopeless. It's not hopeless. But it does require that next generation and the generation after that, my grandchildren, they have to learn something. And that's...
Now, Bush v. Gore, that decision was seen by many as political because you had the Republican appointees voting for Bush and the Democratic ones voting for Gore? No?
No. Wasn't David Souter a Republican appointee? Wasn't John Stevens a Republican appointee?
Yeah, all right.
They voted.
Okay. So did you think it was a political decision, or you thought that was, some people thought it was a very political decision. Did you know in advance it was going to be 5-4 before you even really had the arguments, or
No.
You didn't know? Okay. There's a very famous picture of you driving out that night.
With my son, Michael.
Right. You were driving out of the
looked
court.
a little
like
unhappy.
You weren't too happy about it. I was wondering, what is a Justice of the Supreme Court doing driving his own car? But that was very common then, I guess, right?
Yeah, no, I do. I don't always drive my own car, but
Okay.
I do sometimes, yeah.
So today...
And my car was one of the oldest cars in that lot. And David Souter put on a little sticker which said, it was before the year 2000, and it said, McKinley Roosevelt, 00, okay.
So you've been on the court now 28 years. What are you most proud of having done? And what's the pleasure of being on the Supreme Court? You can't have social engagements with people. You can't go to cocktail parties and say,
yes,
let me tell you what I did at work today or something like that. It's a little bit more constraining. So what is the pleasure of being on the court, and what would you say you're most proud of having achieved on the court?
I think it's a great privilege to be on the court. I mean, there's no doubt. And from a personal point of view, I'd say it requires you in middle age, when you get there, to give your best to this every minute. And you say, is that a big virtue? Yeah, yeah. And the older you get, the more you see it as an enormous virtue. And you know, mucking around with this. You take it seriously, you give your best to it, and if you were to say, what's my greatest achievement, others would have to say that. I don't know. I hope they do say that I did give whatever I had, and it will be for some other people to say whether that was the extent. I hope it's positive, and the extent to which it is and where and so forth will be not for me to say.
So Einstein famously said, if you try something over and over again and expect a different result, that's the definition of insanity. So if somebody asks you a same question over and over again, expecting a different answer, I guess that's the definition of an insane interviewer. But let me ask the question you've already been asked many, many, many times. Mm-hmm. So what do your grandchildren call you?
Grandpa.
Okay, that's the question you're always asked, right?
Yep.
Okay. Now let me ask.
The noise level's high, so you don't even hear it.
They don't call you Mr. Justice, right?
No.
So the question is, I know you're not going to give a different answer, but I have to ask you the question, what is your thinking about all of the issues relating to your retirement?
Yes.
Okay?
Einstein was right.
Einstein was right. Okay. So have you come up with a different way to say the same thing?
All right.
In other words, your position, what you've said before, is you'll decide when you're ready to decide.
Yes.
Okay? All right, I don't think I can say it again, but okay. So let's...
No.
So today, what you do enjoy more than anything else, I assume, is the law, and you love the love of the law, as all justices do. And would you say that when history is written, what you will be most remembered for is being a justice who followed your views for 28 years and had a lot of influence in the court, and that's what you're most proud of having achieved?
If that's what you say, I'm absolutely satisfied.
Okay. All right. So we have some questions from our audience, and I would like to remind everybody, there are signed copies of Justice Breyer's book that are available for sale afterwards, so I highly recommend it, and because it's not too thick, you can get through it easily, right?
You could read it twice.
Right, okay, you can. Or you could buy it twice, too. Okay. So, all right, let me ask you some questions we have here. Tonight, you have referred to the Federalist Papers and Marbury v. Madison and Cicero. In order to be a justice or a jurist, do you need to know history? Same question, to be a good citizen, do you really need to know history?
Some. I'd like it. I mean, it's a plus. It's a plus. I don't know if you have to read the 100 Years' War. I mean, someone gave me a 4,000-page book on the 100 Years' War, which in fact has kept me asleep most of the summer. But nonetheless, you don't have to go back that far. But you could go back to the Magna Carta. You don't have to. But it is indeed helpful to see these ups and downs of the court. Dred Scott was a terrible decision. Plessy and Ferguson, the Japanese cases. And then you see, well, but my goodness, then we had Brown versus Board. Then we have. And so it's never going to be anywhere near perfect. There'll be some terrible mistakes and there'll be some shining moments. And what is it, this institution that is back and forth, and we hope it works all right, and we do our best. Can I quote this, which I always do, is that Camus thing, which you read 1,000,000 times, to heaven the thing.
Right.
But I did read again recently, a French author, Camus, who speaks to my generation, The Plague. It's a pretty good book to read right now, The Plague, and it's about a plague that takes over Oran in about 1947 when he was writing this, and just after the war in northern Algeria. And he says, and the people have some do bad things, some do good things. I always thought, and I think it is to a degree, it's an allegory of the Nazis taking over France. And at the very end, he says, well, why have I written this book? And he said, partly because I wanted people to see the different ways that people behaved in this town. But more than that, I wanted to emphasize the work of a doctor, because a doctor is a person who doesn't philosophize. He just does good. He does it without philosophizing about it. But most importantly, he says, because the germ, the plague germ, he says, will never die. That plague germ just goes into remission. And it lurks. It lurks in the corridors. It lurks in the attics. It lurks in the file folders. It lurks there for one day to reawaken, and then for the education or to the misfortune of mankind will once again send its rats into a once happy city. You see, to me, after reading it particularly, I think he means that to stand for something that's in every person that is everywhere, that bacillus de la peste, that plague germ. It's not a good thing, but it's there in human nature. And what he's saying is, we'll fight it. We'll fight it, and the rule of law is one, not the only one by any means, but it is one weapon that human beings have in trying to fight that plague. And I don't want to see that weakened, that tendency to follow in a country. And 331 million people, every race, every religion, every point of view imaginable. I don't want to see that weakened. And if I can help somewhat by explaining to people what this court's about, good and bad, well, that's what I was trying to do.
So after 27 years, you are the senior member of what might be called the liberal wing of the court. You may not agree with that phrase, but some people would say that. So now you assign opinions for people in the liberal wing of the court when you're in the majority or dissent. But you don't have as many people in the majority of the liberal side as you might want. So how does it feel to wait 27 years to decide who can write the opinions and you don't have enough votes? Doesn't bother you? Nothing you can do about it. Okay. Can you share your chicken a la king recipe? Is one question. I assume you won't want to share that.
It's very good.
What in your life has given you the strongest sense of meaning and purpose?
Meaning, but well, the thing that centers most people in their lives, I'm no different from that, is their family.
Okay. So, I'm sorry?
It's your family.
Right, of course. And you were raised in a family in San Francisco, and you have now, how many children do you have?
3.
And you have
6 grandchildren.
6 grandchildren. Any of them want to be on the court? Any of them want to be lawyers, or they're too young?
No, they're too young. Yeah, one just started college here in New York at NYU. That's the oldest one, and the youngest one is 1 year old. So he hasn't told me yet whether he'd like it.
Okay. So you have said that you don't want to die on the court, and presumably nobody would want you to die on the court. So what do you...
It's Einstein is coming back.
So what is it that you would like to do when you are alive after you're off the court? In other words, would you like to go teach again? Would you like to write? Would you like to just take life easy? What would you like to do?
It's hard to take life easy, but I don't know. We'll see.
Okay, so you haven't thought about what you might want to do, or...
Yeah, different thoughts
things
go through my mind.
Okay. What about the question of President Biden has put together a commission that's going to look at the court, and you have already articulated your view that you don't think expanding the size of the court is a wonderful idea. I think you've said that.
What I've said is that they better be pretty careful about it, because 2 can play at that game. And of course, what's worrying me, and I say this, I try to explain to people in the book the extent to which politics is relevant or not relevant, or present or not present, and in what form in the work of our court. And what worries me is that people will think we're junior league politicians. And if they think that, the second thought should be, why don't I have a senior league politician? And once you begin to think along those lines, 2 can play at that game, as I said. You could have Republicans appointing and then Democrats appointing and vice versa. But I see the overall tendency of that is, given the history, given the way we work, given the country, et cetera, as weakening the confidence of the average person in the decisions of the court. And you can say, what's wrong with that? And I say, well, that's sort of a step towards or away from a rule of law. And if you say, why have a rule of law? You say, okay, look around. It's one of our weapons, as I said, against dictatorships, autocracies, tyrants, irrationality. King John, I don't like you, so I'm going to put you in jail. Too bad, ha ha. And much worse, much worse. So that's what I'm trying to do.
So talk about death penalty cases. Each of the justices is assigned to a certain circuit, as you said earlier, and sometimes you get these death penalty cases come in and you have to make the decision, yes or no. Have you had to make a decision that said it was okay for somebody?
Oh, yes, quite a few. Quite a few. Because we all decide everything in the death cases. So I've had to vote in quite a few. And I wrote a long dissent. I mean, it's 47 pages, but who's counting? As to why the court should reconsider that issue, whether it violates the Eighth Amendment. But I did not have a majority on that dissent. Ruth Ginsburg joined it, but I did not have a majority. Therefore, I lost. And so I have to not just look for excuses and vote. You could do that. I think, I can't remember who did, but vote against every death case. But that would get me nowhere. And but I don't, sometimes I do vote for stays in those cases. Usually when it shows something there. And more often, I'm not, if there's no legal issue, I'm not going to vote against it, if there's no real legal issue.
What did the justices do during this summertime? I mean, they teach, or they relax, or they read cases? What do you do in the summertime?
We have a cabin up in New Hampshire, which we love, on a pond. We were up there with our grandchildren. Okay. They've set up a little soccer thing there, the goal, which has destroyed the lawn. And then we'll go swimming, or we'll... Do
your grandchildren treat you with the seriousness that a Chief Justice or a Justice of the Court should get?
Yes, from their point of view.
From their point, okay. So let me just, in the time we have remaining, ask you, what would you like most people to know about the Supreme Court? If you could say to the average citizen, here's what you should know in a paragraph about the Supreme Court. I assume, it would be something along the lines that it's not as political as some people think, but what would it be you would say?
It would be that it's part of this constitutional system. And this document was set up so democracy decides most things, but there are boundaries. And so we have a Congress, we have a president, and we have a court to see that people don't go beyond the boundaries. And that's our primary job. And we won't always get it right. But don't look to the Supreme Court to save the country, and I think don't look to the Supreme Court to destroy the country, because that isn't a judge's job. A judge's job is to look at the case, to try to do his or her best, reading, thinking about, pondering, consulting with others about how, under the law, which is not computer programming or anything, it's open in many areas. See, I'd like people to understand that. And a judge, once he puts on that black robe, I'm not going to say it's a midnight transformation, but look, a judge, and I have to think this about myself there too, I have to. A judge is there for all Americans. He's not there just for Democrats. He's not there just for Republicans. He's not there just for the president of the party that appointed him. And even if half the country thinks he's a real idiot and they can't stand what he writes, in his own mind and the way he approaches the job, he has to remember he's there for everybody, all 331 million.
Well, I think we're out of time, and I just wanted to say on behalf of everybody here and all Americans, I want to thank you for your 28 years to date of service on the court. I read this book several times to get ready for this. I highly recommend it, and I think you can get signed copies of it afterwards. And Justice Breyer, thank you for giving us this time.
Thank you.